Good evening, everyone. I think this is off. Good evening, everyone. First thing, just want to make sure everyone can hear us. You're not hearing me, sir? All right. I will pull this closer. Is that better? I'm making pull it real close. I don't have a problem doing that. Testing 1, 2, testing. Hear me better? Thank you. All right, what I was going to say is that I want to make sure everyone can hear everything that's being said tonight. So if myself or one of the council members, subcommittee members makes a statement and you can't hear them, feel free to raise your hand because it's a little different room for us. I'm not sure how the acoustics are in here. I just want to make sure that everyone can hear all parts of the proceeding. With that said, I'm going to call to order the State of Rhode Island Coastal Resources Management Council's Rights of Way Subcommittee public hearing to order. It's in the matter of CRMC file 2020-11-084. It's a Spring Avenue extension. Today is Tuesday, November 4, 2025. And let the record reflect the location at the Westerly Senior Center, 39 State Street, Westerly, Rhode Island, and the subcommittee members that are present this evening, as well as the CRMC staff members that are here this evening. At this time, I'm going to turn it over to our counsel, Attorney Hartman, to make some statements as it relates to presentation of opening statements and witnesses here this evening.
Thank you, Mr. Chair. So as we had indicated at the last meeting, tonight's meeting is for the attorneys, the parties present to present opening statements and witnesses. It's not for public comment. That was last meeting. That doesn't mean that public comment is yet closed. At a final meeting, the public will again be able to address the application. But tonight, it's just the attorneys. And specifically, it's the opening statements of both the proponents as a unified group and of the objectors. Once the objectors have closed their opening statement, then the proponents will be able to present witnesses. Again, that's a unified group. They've requested a unified presentation. So they'll be presenting one opening statement. And we ask that these opening statements be very brief. We've been going over the issue at hand for, I think, around 2 years now. And while not everybody here has been present for all of it, this subcommittee has been present and attentive for all of it. So they know the issues, and now it's just a matter of essentially, let's wrap this case into a nutshell, and let's hear some witnesses. So please keep the opening statements brief. We're going to cut you off at 10 minutes. Please try to keep it a little bit more brief than that. Now, before we get to that, I just want to address one issue that came up from last meeting, and that's the presentation of exhibits by the public. Under 1.5.9 of our management procedures, exhibits have to be submitted 7 business days in advance. Now, that doesn't mean that the public can't present information during public comment periods. Public comment periods. They can. However, in order for that information to be organized and categorized to make it a relevant and efficient part of this record, those exhibits should be submitted 7 business days in advance so that the council can properly file that information. If it's just submitted at the hearing, the subcommittee can consider it. However, it's not as useful because it can't be properly filed. Having said that, the proponents and the objectors are subject to the same rules, 1.5.9, and they have submitted exhibits. They've submitted exhibit lists and witness lists, which allows them to submit documents here tonight when they present their witnesses. Mr. Chair, that's all I have now. If there's anything else that needs to be addressed, I'd be happy to address it.
Any questions from our subcommittee of Attorney Hartman? Okay. We will proceed with opening statements in the order that you choose to present. Question.
I just wanted to address a housekeeping item. There were 3 pending motions that were never ruled upon. I assume that they have at this point been administratively denied. I just wanted to see if we could put that on the record so that we had a clean record. It was the AG's motion to quash district's notice of deposition, the district's motion to compel the AG's discovery, and the district's motion to exclude Susan Cornacci as expert reports and evidence. Those were motions that were punted out at prior meetings and never ruled upon. And like I just said, I expect that the ruling is going to be a denial. We just would like to have a clean record of that for the case going forward.
Do the proponents have any input on that?
For the committee, our understanding was that those were still.
We can't hear these people.
I'll try to speak up. Our understanding was that these motions were still pending, and so we're not under the expectation or understanding that those motions had been denied and that they were still held during the pendency.
If I may, with respect to the motion that's directed at Caroline Contrada, having had Susan Cornacci's testimony, I think that the understanding was that that would be addressed when she's actually on the stand. And it might, turn out that it might turn out to be moved, depending on how we present her testimony and so forth. But my understanding was that that one was held in abeyance until she was actually sworn as a witness, and the subcommittee can see how her testimony is going.
All right. I see some hands being raised, and I think there's some issues of people not being able to hear the individuals that are speaking. So if anyone's going to speak, I'd ask that either hold a microphone or sit with the microphone in front of you during your presentation. But also, if you're making a statement from the row or whatever, just walk up to the microphone and grab the mic, because I do want everyone to hear. That was relative to some pending motions that were on the floor, and our attorney is going to address it.
Mr. Conley, did you have?
I do. Thank you. On behalf of the town of Wesley, although those motions don't directly involve the town of Wesley, I'll say as regard to the motion as to the intervener in the testimony, I was our understanding as well that that would be addressed at the time that the testimony was presented to the committee. As to the other pending motions, I would suggest that they're not on the agenda tonight. Although they're not directed directly to the town of Wesley would appreciate the opportunity to consider what arguments may impact us, and therefore would ask you to defer a ruling on those motions this evening.
Mr. Farside, do you have any additional comment?
No objection to deferring ruling to a future.
Can we just have, is that microphone on? Okay, there you go.
No objection to deferring ruling to a future proceeding, as long as the record's clear that that's what we're doing.
Okay,
Yes, my recommendation would be to defer in that case, Mr. Chair.
all right, that's what we will do. And you may proceed.
Good evening, Mr. Chairman, members of the committee. My name is Liam Conley, and I represent the town of Wesley. With me this evening is my associate, Sarah O'Toole, and Attorney Mike Rubin, representing the intervener in this matter, and Special Assistants Attorney General Julia Harvey and Rachel Rebello, representing the state of Rhode Island. As indicated in the initial remarks, it's our intention to make a collaborative presentation to you and present a unified case on behalf of the proponents, and we appreciate you allowing us to do that. I also want to thank you very much for the attention that you have given this matter already over about the past 2 years. And it's been thorough, and we very much appreciate the opportunity now to sort of get to the nuts and bolts of this case. Spring Avenue right away is the shining path to the sea that you can see right on this photo right here. And we will present substantial evidence to you showing that that shining path to the sea has been and still is a public right of way and should be designated as such by the Coastal Resources Management Council. We are confident that there are two equally well-substantiated legal bases for concluding that that shining path to the sea, Spring Avenue right-of-way, is a public way that belongs to all of the people of the state of Rhode Island. Both of those legal bases will show you that the Spring Avenue right-of-way is a public right-of-way through dedication and acceptance. The classic means of establishing a right-of-way. Dedication simply means that this parcel of land has been devoted to the public use by an action through the owners. Acceptance can be by some official act of the sovereign, or by showing that the public used and accepted this right of way. Both have happened here. Both of those legal bases will be supported by substantial evidence. Now, I know you've seen some of it. I don't mean to belabor it. But what that substantial evidence simply means is that it's information which is reliable, information that a reasonable mind could conclude that the evidence here requires you to find that this is a right-of-way and should be designated by the Coastal Resources Management Council as such. Now, one of those legal bases is the statutory dedication and acceptance process. That statutory process was established through public laws specifically enacted for the town of Westerly. Those public laws were enacted in 1923 and amended in 1925, and we will present you with the official records of the enactment of those public laws. You'll see, pretty simple process. Requires three things to satisfy the statutory requirements of those public laws. One, approval of a town highway commission, the Town of Westerly Highway Commission. Number two, approval of the Town of Westerly Zoning Board. And number three, acceptance by the town clerk for recording. All three requirements of that statutory process have been clearly and unequivocally been met for the Spring Avenue right-of-way. Now, frankly, we could stop there, and that would meet all the legal requirements and require the designation by the council of Spring Avenue right-of-way as a public right-of-way. But there's more, because the Spring Avenue right-of-way also requires designation by the council because it has also been dedicated and accepted by common law principles. Now, it's common law. We have a statute. Why do we need common law? Well, The common law really are those principles and standards that have been refined and developed through really centuries of analysis. And then those principles are embedded in American jurisprudence. In this case, the common law requires that a plat plan depicting a road or way, dedicating this roadway, the Spring Avenue right of way, to the public, and that acceptance of that dedication happens by public use, acceptance by public users. We are also going to present to you substantial evidence that meet the common law elements for establishing a right of way, dedication and acceptance. For instance, we're going to show you maps from 1886, 1889, 1901, 1920, showing the development of the Weekapaug Beach area, roads being developed. And what do you see throughout that entire time period? Is this shiny path to the sea, the Spring Avenue right away, through all of that historical development of the Weekapaug Beach. Really, you know, by the 1800s, the Weekapaug Beach was really already a thriving beach community. There were trolley stops, there were hotels. It was a wonderful place to visit. And the only access to the Weekapaug Beach, to this exquisite and pristine piece of round coastline, the only access for all those people from the trolley cars and the hotels was the Spring Avenue right of way. Now, you will hear testimony in this case. We're going to present you witnesses in addition to those documents that I just mentioned. For instance, I'm not going to tell you all the witnesses, but just in this 10-minute time period, for instance, Paul Amma. That's a witness with firsthand knowledge of all kinds of people, fishermen, others seeking the recreation and access to this beautiful shoreline, based on his regular presence there through at least 1970. So we're going to begin in 1886 and get you all the way to 1970. Beyond that, we're going to present testimony from Gene Armstrong Shikoka, Sir Costa. Sir Costa, I have another hearing with the name of Shikoka. I apologize. Gene Armstrong Sir Costa. That will also be first-hand personal knowledge testimony of people accessing and using the Spring Avenue right of way through the 50s all the way to the 80s. Now, you're finders of fact here when you sit here in this capacity. And as finders of fact, you will make assessments of credibility. The witnesses we present to you are here for one reason. They're here to tell you the truth, and they're here to do the right thing. Now, you're going to hear witnesses from the fire district as well. And you need to assess their credibility. But when you do that, you need to understand, please, that they have a special interest. They are interested in protecting their privilege and exclusive access to this Rhode Island coastline. Now, they're good people. They're sincere in their beliefs. But you will see that the facts and evidence don't support their beliefs. Therefore, you cannot accept their beliefs. Rely on the facts and evidence. Because when you rely on the facts and evidence that you will listen to in this proceeding, you will see that there are two distinct legal bases for requiring designation of the Spring Avenue right of way as a public right of way. They are not and by any means mutually exclusive. In fact, they are independently sufficient, more than sufficient, to require that upon the conclusion of this proceeding, you recommend to the Coastal Resources Management Council, the full council, that the Spring Avenue right-of-way, this shiny path to the sea that we see right here, be designated a public right-of-way. And once again, return the ownership to the people of the state of Rhode Island, no buttons required. Thank you.
Thank you. Okay. Thank you.
Mr. Fresha, before you begin, I just have a question about the handout we just received.
Yes,
This handout, has this been filed previously?
no,
Okay, so this is just for reference purposes, or are you also intending to submit this as an exhibit?
reference purposes.
Okay, thank you.
Good evening to the subcommittee. Can you hear me? See how far I can get.
But travel.
I'd like to thank the CRMC staff for setting this up tonight so well and so quickly. This photograph has what appears to be a beach and a path on it. To date, we've seen no evidence, A, that the sandy strip that they call the shiny path exists on Spring Avenue Extension, nor have we seen any evidence that a single member of the public ever used that so-called shiny path. So I want to set the record straight on that before I get into my own opening. Spring Avenue Extension is not now.
I just want to interrupt 1 second. I'm not sure for those here, we know who you are, if you've identified yourself and your client,
Please
please.
forgive me, Attorney Joe Farside and Attorney Natalie Orlandini, both for the Weekapaug Fire District. It's a
Thank you.
pleasure to be here with you tonight. Spring Avenue Extension is not now and has never been a public right-of-way to the shore. It's a piece of land owned by the fire district containing a private easement for fire district property owners. The subcommittee must find by clear evidence, a manifest intent by the owner of Spring Avenue Extension to dedicate it. The Rhode Island Supreme Court has stated that such an intent will not be lightly presumed. And we will get to the slides within our 10-minute allotment, I promise you, but we're not there quite yet. The subcommittee must also find, by clear and convincing evidence, acceptance of the dedication by the public. Clear and convincing. That's what the Supreme Court says must be proven to demonstrate acceptance. This case is the antithesis of clear and convincing. Instead of being clear or convincing, the proponents need you to buy into various assumptions, inferences, speculations to try and meet their burden of proof. Instead of being clear and convincing, the proponents need to employ numerous expert witnesses who are tasked with convincing you that dedication and acceptance happened here. It shouldn't require multiple so-called experts to convince you of something that should be simple. These experts include multiple title attorneys who don't even agree with each other, surveyors, a coastal geologist who claims to also be an aerial photography expert, archivists, and the like. Again, SAE is not now and has never been a public right-of-way to the shore. The proponents in this matter are trying to speak this right-of-way into existence. This piece of land has been fenced off undeveloped and untouched. The statute that the proponents rely upon does not serve to make Spring Avenue Extension a public right-of-way by its own terms. You need to read the actual language of the 1923 statute, which we will get into for you during this proceeding. The fact that a 1939 plat bears stamps of the zoning board and the highway commission and was recorded does not make all of the ways on that plat public. This is confirmed by at least two other roads shown on that plat, Meadow and Shawmut, remaining private roads to this day as conceded by the town itself. In any event, there is a later 1960s era plat of a completely different development in Westerly with the same stamps, and those roads remain private as well. The incipient dedication theory that proponents rely upon does not serve to make Spring Avenue public either. Even if a dedication occurred, there was never any acceptance. A 1940 report by the town council's commission confirmed that Spring Avenue Extension was not a public right-of-way as of 1940. The proponents' experts go so far as to claim that that 1940 report makes it more likely that Spring Avenue Extension was a right-of-way at that time when it was never even listed on that report. The proponents like to ignore many other inconvenient facts. Testimony from numerous witnesses, living and deceased, that Spring Avenue Extension was never a passable right-of-way to the shore for anyone, Weekopoggers included. Aerial photos do not show evidence of a path existing over Spring Avenue Extension. In 1942, the Weekapaug Beach Company, the predecessor to the fire district, granted an easement to the Army Corps of Engineers. That easement was not granted by the town. It was granted by the owner of the land, the Weekapaug Beach Company. There were 64 private easements specifically over Spring Avenue Extension given to various landowners within Weekapaug between the 40s and 1965. That brings us all the way up to 2008 and 2020, when the town twice commissioned reports by its legal counsel as to whether Spring Avenue Extension was a public right-of-way. And Mr. Solovicic and the current solicitor, Mr. Conley, who's here tonight, both issued memos indicating that they did not find evidence that Spring Avenue Extension was a public right-of-way. Proponents are guided by the blind hope that this subcommittee will sympathize with them, ignore their burden of proof, and bend to public pressure to access what we call the In Beach, a piece of land owned by the fire district and its predecessor since at least 1884. We strongly urge this subcommittee to see through this attempt, dogged, deliberate, relentless as it may be, and stick to an application of the law to the facts in this matter. I realize I'm down to a couple minutes, and I do want to draw your attention to a couple of slides in the slide deck. The first will be slide number 4, which shows the current location of, or shows the location of Spring Avenue Extension, an image of what Spring Avenue Extension had looked like for the foreseeable past. A fence, overgrowth, trees, impassable. I'd like to also show slide 10. Slide 10 includes an image of the 1939 plat map that the proponents are relying upon here for statutory dedication. We will prove that the plat was related to the 1939 deed of Spring Avenue North of Ninigret to the town, not any conveyance of Spring Avenue Extension to the town. And this image has, and you'll see this image a lot, has a highlighted portion of Spring Avenue, which is the part of Spring Avenue that this plat dealt with and that the deed to Spring Avenue North dealt with. The fact of the matter is Shawmut and Meadow Avenues appear on this plat map. And if you turn to the next slide, slide 11, those roads appear on the town's list of private roads. If that plat map shown on slide 10 effectuated a dedication and acceptance of all the roads shown thereon, including Spring Avenue Extension, Shawmut and Meadow would be public roads today. Finally, I'd like you to turn your attention to slide 23. And just take a moment for yourself to flip through the next 4 or 5 slides, which are all aerial photographs, of some form or another, of Spring Avenue Extension. That shows Spring Avenue Extension as being overgrown, covered in seagrass, covered in trees, bushes, and other growth. These images, especially the 1974 image on slide 27, clearly show the fire district's boardwalk path to the beach. But when you look to the left of that boardwalk path, between that path and the building that you see to the bottom corner on the left-hand side, there is no other path leading to the shore. The fire district looks forward to proving or establishing the fact that the proponents cannot prove their case, and that Spring Avenue Extension is an impassable, fenced-off piece of land and should remain that way and within the fire district's domain in the future. Thank you very much.
Thank you.
May, Mr. Chairman, on my first witness.
Yes.
April Rubin of behalf of Caroline Contrada. I'd like to call Joe Priestley to the stand. And while he's coming up to the stand, I take care of some housekeeping, which is that I have these binders, which are exhibits that have been marked but not yet admitted. Obviously, they've been shown to council. Or available in advance, careful there. And if I could allow the subcommittee members to peruse them as testimony goes forward. They're in binders and I'd like to hand them up.
And Mr. Rubin. Mr. Rubin, these documents you're about to hand to the subcommittee, were they included as part of either the witness lists or exhibit lists as topics that might be discussed?
Yeah, these exhibits, a portion of them were filed with the subcommittee and council 7 days ago. And another portion was with gracious permission of council, was identified to council 6 days ago, and then were submitted yesterday. But they all concern testimony by witness Priestley that he's going to get into, just so that you can follow along with the testimony more easily.
But that was indicated that you might be talking about the subjects that are in the
Yes.
episodes.
Yeah.
Okay, now that
These were
list was
associated
submitted prior.
in my listing. These were associated with Attorney Priestley.
Okay, that's okay.
Watch your step, please.
Yes, I will. I'll just hand them to the chair and then the chair can distribute them. Thank you.
Thank you.
And if I might, perhaps for the witnesses being sworn in, I'll just need to enter this piece of.
President, I'm going to swear you in now. Will you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Will you please state and spell your name for the record?
Joseph A. Priestley, Jr., JOSEPH,
Thank you, Mr. Priestley.
And Attorney Priestley, can you tell us your occupation, this address?
I'm a lawyer. My offices are at 85 Beach Street in Westerly.
Okay. And how long have you been at that Westerly location?
Since 1986,
And how long have you been an attorney?
since 1978.
And you're admitted in both New Hampshire and Rhode Island?
I was admitted in New Hampshire, moved to Rhode Island in 1980, and let my New Hampshire admission lapse. I'm only admitted in Rhode Island.
Okay. And in what area of legal practice do you concentrate?
I basically do real estate development, real estate conservation, real estate titles and municipal work.
And in what municipalities within the state do you mostly concentrate?
Oh, the great majority of my practice is in the town of New Shoreham, which is Block Island. I also work in other towns throughout Washington County and occasionally even get to Kent County, but that's rare.
May I sit while I'm asking?
Yes.
Most of it is in coastal communities then?
Yes, sir.
Okay. And are you familiar with the Weekapaug area?
Yes, sir.
How so?
Well, I've lived in Westerly. I lived in Westerly from 1980 to 2004. I used to take my dogs and my kids walking on the beach down there.
Does your work on Block Island and other coastal communities require you to review plats and deeds?
Yes, sir.
And how far back in time do you have occasion to look back at, let's say, deeds?
Well, it all depends on what you find when you're looking back. The standard rule of law now is you go back 40 years. When I started, it was 60 years. And at the time I started in 1980, I often went back to the 1880s. I've occasionally gone back as far as 1732.
And how far back in time have you had occasion to look at plats?
Well, pretty much that same amount of time, although there was one plat from 1661 that I've also referred to, which was the initial platting of the town of New Shoreham.
Does your work on Block Island and other coastal communities require you to perform title work with respect to rights of way?
Especially in New Shoreham, more than half of the residences on Block Island don't have frontage on public roads, but are located on private rights of way. So I've done work regarding rights of way since the beginning of my career. I've also testified regarding rights of way in the Superior Court before.
In fact, I hate to bring it up, but I think that you testified in the Musqueamacet case.
Yes, you cross-examined me.
It's nicer doing it this way. Were you, what did the Supreme Court do with respect to your testimony?
I think they found it convincing.
Do you write title insurance through a title insurance company?
Yes, through Commonwealth Land Title Insurance Company.
And for what type of clients do you perform title work?
Mostly private clients, though I've represented the Block Island Land Trust for over 30 years, and I've done all of their acquisitions. I've done acquisitions for the Fish and Wildlife Service, for the Conservation Fund, for Nature Conservancy. But majority of the work is just simply for private clients, and usually, residential transactions, things like that, although also sometimes larger tracts for
Excuse me.
developers.
Go down to almost sometimes,
Larger tracts for developers, excuse me now.
yeah, because your voice is not coming out that loud.
What are some of the banks that you perform title work for?
The Washington Trust Company regularly, Bristol Savings Bank recently, Kentucky Credit Union in the past, Centerville Bank, all the big ones, JP Morgan, Wachovia when it was a bank, Rhode Island Hospital Trust when it was a bank, Bank of America, whoever the client chooses to finance through, I'll work for.
Okay, now in connection with a typical title search that you would perform, would you reach an opinion on title with respect to real estate?
Have to, yes.
Roughly how many such opinions on title with respect to real estate have you rendered in the course of your career?
Well, I've been doing it for 45 years. I don't know, a couple thousand maybe, give or take.
And roughly how many recorded multi-lot subdivision plats with respect to real estate have you examined in the course of your career?
Several hundred.
When examining a title, what are the first steps that you undertake?
We usually start with the deed to the property, find out and then trace it back to previous owners and previous. Until you reach a point where you've gone far enough back, where you found a starting point that's secure. Then you come back forward, checking to make sure that all the links hold together, so people haven't conveyed it out, people haven't mortgaged it and not been discharged. Basically making sure that the trail of ownership traced backwards is solid when you come forward.
Is title searching boring?
I've been fortunate enough to have some very interesting titles. It can be boring if all you're doing is searching for mortgages for properties that have been conveyed hundreds of times. But if you're trying to look at properties that haven't been conveyed, that have been tied up, you can often find yourself involved in quite a little puzzle going back to tying links together coming forward. So I've always enjoyed it.
Well, explain the idea of a puzzle, if you put it. Can you give us an example?
I had a client who owned land in the town of Richmond. And it was a large piece of land, and a town road ran up to about 100 feet short of it, running north-south, and then about 100 yards north of it, and then picked up again about 100 yards south of it and ran down to Route 1. And we were pretty convinced that the gap was actually a public highway, although it was essentially completely overgrown forested. But if it was a public highway, my client could subdivide the property. If it wasn't, he was stuck with an existing lot. So I started looking, and basically searched through the town of Richmond, trying to find where the road had been created. And I reached, I think, 1739, and I hadn't found anything, except for I found that in 1739, the town of Richmond had split off from the town of Charlestown. So I went to the town of Charlestown records and went to, I forget the exact date, sometime in the 1750s, when the town of, vice versa, 1750s, 1730s, when the town of Charlestown had split off from the town of Westerly. So originally Westerly, Hopkinton, Richmond, and Charlestown were a single town. So I went to the land records of the town of Westerly, buried myself in the vault downstairs, and found in 1732 that the town of Westerly had declared that strip of road a public highway, and was able to convince the planning board in the town of Richmond that they had, and the subdivision was approved. That was fun. It took a lot of work.
You had to go to three towns.
Well, I went to 3 towns, but also some of the, for instance, there were heirs. Then after that, you're trying to prove it. It's one thing to do that, then you're trying, but along the way, you're just trying to locate where the property is. So you're tracing titles to all the adjoining maps. And, I ended up in Little Compton finding a probate estate, and Tiverton finding a probate estate, just to tie the links together for adjoining property, so I could convince myself that the strip that I was actually looking at was actually the strip that was the road.
And it seemed from what you were saying, if I understood it correctly, that it was a private person who was trying to establish it as a public highway.
Yeah, so yeah, it was a private landowner who abutted it. The town wasn't opposing it.
Right.
They were just simply saying, it doesn't look like one to us, prove it.
But
It didn't look like a road, it looked like a woods.
that circumstance happens that a private person will assert a public right of way.
That's what happened in that case, yeah.
What type of documents form a chain of title?
Deeds, basically probate estates, you'll find easements, you'll find liens, you'll find mechanics liens, you'll find mortgages. Any document reflecting an interest in real estate. You can have plats, which also, plats of lots, all of those form part of the chain of title.
And for what purpose do you do that? Do you look at these materials?
You look at that to determine the ownership of the property and what it's subject to. For instance, Jack Smith may own the land and John Jones may have an easement across it. You look for things like that.
And what is an easement?
An easement is a right to use land of another for a specific purpose specified in the easement document.
Is a right of way an easement?
A right of way is an easement, yes, or can be an easement.
And why in particular do you look at plats?
The plats will show dimensions of land. They may show roads across land. They may show how land was divided and created, divided, and meant to be used.
Now, what is the resource you use to conduct a title search?
You go to the town's land evidence records, and when I say the land evidence records, the town sometimes refer to land evidence records and records of plats. Those combined are what I mean when I refer to land evidence records.
And conceptually, what is the land evidence records? I mean,
It's usually a vault in a town hall with, in my day, old books. And then the books got smaller and they got typed instead of handwritten. And then you have also old maps and newer maps. And nowadays, a lot of it is electronic and on a computer. And in fact, many of the towns now don't make any paper copies of the documents. The only way you find the more recent deeds are on the computer. But in the days that I'm talking about in this case, it's basically books, maps in the various town halls. In this case, the town hall of the town of Westwood.
okay. And what establishes the land evidence records? Is it the Recording Acts or?
The clerks in the various towns are authorized by statute to record documents related to real estate. The town clerks have throughout history maintained those records.
And what qualifies as a document that is part of the land evidence records?
Any document that the clerk records in the land records or in the plat records.
So, for instance, what about tax assessment plats? Are they part of the land evidence records?
No, they're not. They can be helpful, but they're not.
Okay. Tax assessors cards?
No, sir.
Okay. Zoning maps?
No, sir.
Okay. Building plans filed with the building inspector?
No, sir.
Highway maps in the DPW?
Highway maps are different because the state will take highways in certain instances, and those maps of takings are actually the most recent and clearest form of the ownership of the specific highway. So although they're not, and they're usually kept in the town hall, so yeah, they would be part of the land records.
If there was a condemnation or something like that.
Yeah,
like a general highway map.
You look for yeah, it would be what you'd find is a condemnation, what would be called a condemnation plat.
Right.
That's what I'm referring to.
Okay. And how about town council minutes? Are they part of the land evidence records?
No, they're not. However, in the Richmond case I told you about, only place that I found that laying out and taking of the highway was by going through the town council minutes and actually finding where the town laid out took a highway. So it was necessary so that would actually be a document affecting title that wasn't in the land evidence records.
And what about reports to the town council? Are they part of the land evidence records?
No, sir.
And the particular town council minute that you referred to, how old was that?
Well, that was 1732, but there are other that if I hadn't found ones on other cases that were newer than that, I never would have found that one because I wouldn't have looked for it.
Now, you mentioned, no to a number of the documents that I referred to. Why aren't they part of the land evidence records?
Well, they're just not. They don't reflect the ownership of the property. They're in case of the assessor's records, they're the assessor's best instrument for assessing taxes. In the zoning map is an overall map of the town, and again, you use for zoning purposes, but it doesn't accurately establish boundaries.
And what about the clerk's index cards to the land evidence records?
Those aren't part of the land evidence records, but they're very useful in finding your way through them. And without the index cards or the index books that they used to keep, where each document that came in would be recorded, you'd never find the documents.
But they're not themselves the land evidence.
No, sir.
Okay. And where do you physically do title searches?
Well, I do them in the various town halls in Washington County. Lately, I'm getting older. I'm not going to I'm with all of it in the town of Durham, but I've done it in the town of Narragansett. the town of Sutherland, the town of Charlestown, Hopkinton, Westerly, Richmond, occasionally Jamestown, a couple times in Newport, but always in the town hall, in the town hall and the town clerk's office in the vault.
Now, turning to the subject of this case, or the so-called Spring Avenue extension, generally, what steps did you take?
I found a deed to one of the lots in the platting of Weekapaug. I traced that deed back to 1884 and found a deed into the Taylors from I don't remember who, but it was a deed of the entire portion of land that's set forth on the 1920 plat. And then I started running from John Taylor forward, each and every conveyance that was conveyed out. What I didn't do was to make sure that, with regard to all the various lots, was to make sure that there was nothing faulty in the conveyances. So if I found the conveyances forward, the conveyance out from him, I assumed it was a good conveyance because I didn't need to tell you who owns lot 84 and who owns lot 86. I did check the record to see if there was ever a conveyance out of Taylor of this 50-foot strip of Spring Avenue that runs south of Minnigman Avenue that we're talking about here. That was ultimately conveyed to the fire district, and the fire district is the current owner of that strip.
Okay, so you recognize that you don't deny that the Weekapaug Fire District owns the fee, the underlying fee of Spring Avenue Extension.
They own the underlying fee.
Now, without telling me your ultimate conclusion, did you reach an opinion as to whether the contested strip comprises a public right-of-way?
I did.
Now, for the purposes of understanding the asserted dedication of the right-of-way dispute, I'm going to ask you if a discussion of your analysis can start with the year 1920. Is it logically possible?
Yes,
Why is that?
because in 1920, well, the 1920 Mackenzie map that I think you're going to refer me to, recorded in 1921, was the first map that I found where there was a clear public dedication of the strip of land we're talking about.
And approaching the witness, I'm going to show you what is Joint Exhibit I. Can you identify that?
That is sheet one of the map of Weekapaug Beach belonging to the Weekapaug Beach and Land Improvement Company, Westerly, Rhode Island, August 27th, 1920, by Thomas Mackenzie, certified engineer, and is recorded in the town of Westerly, September 3rd, 1921.
Okay, and is that the same map that you were just referring to in your testimony from 1920?
It's one of the three sheets of that map.
Yeah, okay. And showing you what has been pre-marked as Proponents Exhibit 1. Can you compare that with I think it's Exhibit I that you were just looking at, and tell me if that's the same thing?
Yes, it looks like the same thing to me.
Okay. I would ask that if I can present this to Mr. Hartman, that this be admitted into evidence as an exhibit in full.
Is there any objection from the opponents?
No objection, it's stipulated.
Understood. Admitted in full.
Now I'm going to hand you this little pointer because we'll need that.
What,
I think it goes like this. Just like that. There's your little dot. And so you this pointer.
push that down on fine?
Yeah, don't try that. There you go.
You see.
What happened in that year? Let's see. Showing, looking at Exhibit 1. Let me skip ahead. Now, how are you familiar with that plat?
During my examination of title to this strip I found in the land records.
Okay, and you see that I have an item on the easel. Would you compare that, what is on the easel, to Exhibit 1, also known as Exhibit I?
It's the same map.
Okay. Now, comparing what you're holding in your hand to what's on that easel, which more corresponds in size to the actual map as recorded?
Oh, this is much closer. This is a substantial reduction. This is approximately the size, although not quite as large as the map in the town hall.
Okay, so you're referring to the one on the easel
One on the easel,
corresponding.
yeah.
Okay, thank you. And where is that kept?
It's located in the vault in the town of Westerly, in what is sort of the inner vault. As you walk into that vault and where the computers are now set up and where the newer books are, there's a spiral staircase. Go down the spiral staircase, you end up in a little basement vault, and that's where the older deeds are and the older plats are in large plat books.
Now, can you just give us a general description of this sheet one?
Sheet one is a map that shows a public highway to the left, highways, the highway called Shawmut Avenue running east to west, a highway called Meadow Avenue running north to south, a highway called Spring Avenue running southerly and crossing Ninnegrid Avenue and going down to the beach, and then a highway called Ninnegrid Avenue running east to west, continuing west to east, excuse me, and continuing further east if you have the other sheet of the map. But it basically shows a series of roads, then a series of lots adjacent to the roads created for development or proposed for development.
Now, was this plat actually approved or endorsed by the officials of the town of Westerly?
No, it was simply recorded in the land records by the owner.
And why wasn't it so approved or endorsed?
In 1920 and 21, there was no requirement for town approval. A landowner could record a plat.
And when did that requirement come about?
I don't know when the subdivision rules in Westerly were first adopted, to tell you the truth. But I do know that there was a 1923 statute that related to the recording of plats showing roads to be out.
And so this was before that statute.
This was before that statute as well, yes.
Now, do you see the location of the do you see the location in dispute on this plat?
I do.
And using the laser pointer, will you point that out, point out the location? And what I'm going to do, if I might approach, is show you the next placard.
Ruben, if I may, the subcommittee members, do you all have a clear view of the exhibits?
I can move back.
I just want to make sure, is everybody okay with that?
Yep.
Okay.
Thank you. Yeah.
Yeah. Now, I'm going to turn this so it's right side up. And while that's on display, I'm going to show you what's been marked as Proponents Exhibit 2. And tell us if you can identify that.
That appears to be an enlargement of the portion of the Mackenzie plat, the 1920 plat, showing where the 50-foot strip of Spring Avenue running to south of Ninnegrid to the shore is located, and showing that strip in particular. Right there.
Okay, using your pointer, you're highlighting the strip. if I might have exhibit 2, because I think you can use that placard there. Does the placard correspond with exhibit 2?
Yes, sir.
Okay, if I might have this admitted into evidence by Mr. Hartman.
Mr. Forsythe, is this stipulated as well?
It is.
Thank you. It had been full.
Now, looking at proponents exhibit 2, would you just please place the strip's northern end and southern end in relation to the location, of other features on the plat?
Now, you've got lot 16 to its west, which butts along Minnegood Avenue for a length of 82 feet. Then you've got a boundary between lot 16 and 17. And lot 17, which runs along Minnegood Avenue for 128.7 feet, then runs southerly, bounding on the 50-foot strip for 185.9 feet, and bounds easterly on this, on the 50-foot strip, and southerly for 91.15 feet on the beach. Then you come to the strip itself, which is a 50-foot strip bounded on the east by lot 17, bounded on the west by lot 18.
You might have that reversed. You might mean
Bounded on the west by lot 17, bounded on the east by lot 18. And it's open at the south to the beach, and it's open up the north to Ninnywood Avenue, and then continues on heading north.
now, is this 50-foot strip open?
Yes, basically, there's no line along the portion of the 50-foot strip that butts Ninnywood Avenue, and there's no line across a portion that butts the beach. What there are two-dimensional measurements, and those are found on the map wherever there's an intersection of a curved highway with another highway, or a curved highway with another feature. So you have them. So you've got a 50-foot strip that, if it were simply a rectangle, would be 50 feet wide throughout. But as you head south, it hasn't quite come together, and it's 50.5 feet there. And as you head north, it sort of widens something with the 55.13 feet. But it's a clear open shot across Ninnywood Avenue to the north, and you'll find a similar thing on the plan on the intersection between Shawmut Avenue and Spring Avenue further north.
Okay, let me go back to placard that represents exhibit 1, also known as exhibit I, and using the laser pointer, would you demonstrate that where you're referring?
Here, so the two dimensions I just referred to are here and here. If you look here on Shawmut Avenue, which curves along Spring Avenue, there's a similar dimensional feature, which I can't read from there, but it looks for me from here like about 52.3 feet. So even though Shawmut's 50 feet wide, the intersection with Spring Avenue is slightly wider. There's another dimension there. I don't know what that dimension is, but well, that's a 50-foot dimension on that.
Right. And referring to exhibit 2, which is the magnification or the flow up, if you will, there is a dimension across the width of Spring Avenue partway down. Is there not?
Yeah, the dimension, the width of the avenue is 50 feet wide. It just happens to be at points of connection with points of lots, it gets wider in certain spots. In its principal length, it's 50-foot wide roadway.
Okay, now, are these these dimensional lines that you're referring to, are they lines of closure?
I'm going to object to this line of questioning. The witness is a purported title expert, not a purported expert in land surveyance. Thank you.
I think he's examined so many plats, you do get the hang of it after a while.
There needs to be a foundation laid. Thank you.
Mr. Rubin, would you like to proceed with laying more of a foundation for this? I understand that has mostly already been done, but if you want to.
Sure. You're not a surveyor, are you?
No, sir.
Okay. But in the course of your career, you've had to examine how many subdivision plats?
Several hundred and more and several hundred more plats prepared by surveyors. You know, single lot plats and various road plats and such.
Okay, so when you say several hundred, are you referring to recorded plats?
Yes, sir.
Okay, and are you referring to multi-lot subdivision plats?
Yes, sir.
Okay, and so sort of beyond that, you've had to look at other plats that are not recorded.
Or recorded plats of single lots, you know, yeah. And I also regularly will work on, you know, on development projects, plats that never get recorded.
And through that, have you come to understand some of the symbols and representations that are used on plats?
Yes, sir. I've learned how to read plats fairly well over the years. I can distinguish a boundary line from a surveyor's line, or a surveyor's measure from a line that creates property rights. As shown here, you know, and that aren't set anywhere, particularly on a lot, but just seem to be somewhat randomly placed.
And why do you need to know that?
Because you got to be able to read a map if you want to do the work I do.
So I'll pose to you the same question. Are those lines that you've been most recently referring to? And I'll identify the one marked 50.5, the one marked 50, and the one marked 55.13 on the representation of what we've been calling Spring Avenue Extension. Are any of those lines of closure?
I renew my objection. Foundation's not been go outside the scope of this expert report.
So the practice of the agency has not been to qualify witnesses as experts. However, the subcommittee can consider the credentials and experience of the witness in determining the weight of the evidence that's presented. So the witness can answer, but it goes to the weight of the evidence and not necessarily to the expert opinion.
What you didn't mention was that on the recorded plat, the line, every line you referred to, as well as the angle lines that you didn't refer to, are all in red. They're the only lines in red on the plat. All of the lines of closure, lines creating lots, the lines creating roads are bold black lines. Those lines are simply, those lines are surveyor's measures, and that the distance measure, which has a red line and arrows in both ends, is obviously a distance measure and is not a closure with it. That 55-foot strip runs unclosed from the beach up through across Nitty-Grit Avenue into Spring Avenue.
And what about the line work in terms of the weight of the line? Is that the same with the boundary lines and the lines, the dimensional lines that we've been referring to?
The boundary lines we've referred to are bold and black. The surveyor's lines are not only not continuous, you'll see they're dotted and dashed, and they're also in red and narrower.
The width of the line itself is narrower.
Yes, sir.
Right. And what about arrows?
Well, arrows are used, so you see here, arrow point, you've got a distance of 50. The arrows point where the distance runs from and where it runs to. So on this one, 55.3, you've got an arrow here, you've got an arrow here. You've got an arrow here, runs 267 feet to some point over the distance, but it's not and again, this line, this 267-foot line that cuts through lots 18 and 19 is not a boundary line, it's simply a surveyor's line. The lots follow the bold black dimensions, just as the right of way roadway follows the bold black dimensions.
Now, the boundary lines don't have arrows on them, do they?
No, sir.
Okay. Now, having located it and generally described it, would you now indicate how it is labeled, if at all, and you might refer to exhibit 1, otherwise known as exhibit I, as well as the magnification.
What do you mean, how it's labeled?
Is there any labeling that you would ascribe or attribute to the strip that we're referring to?
I would describe the name Spring Avenue as running a 50-foot strip that runs from north of Ninigret Avenue and then continues southerly along the strip. The strip itself is not separately named, just as the portion of the roadway that continues easterly along the shore is not separately named.
Okay, so for instance, the name Ninigret Avenue.
You see it here.
Yeah.
You don't see it here, but the assumption is that Ninigret Avenue continues all along the way there.
Thank you. Okay, having located the disputed strip and having generally described it, having commented on the labeling and measurements, would you now compare it to the building lots shown on the plat?
The building lots are outlined in bold, both on their easterly and westerly dimensions and the northerly and southerly dimensions. So they basically are closed off quadrilaterals of some sort. This is a quadrilateral that's fully outlined as on its easterly side and its westerly side, but opened on its northerly and southerly. And the building lots are numbered as not building lots. This is not a numbered lot.
This meaning the subject, right?
Meaning the part we're talking about is not a numbered lot.
Right.
This is a strip with a defined width. The building lots don't set forth widths, but do have the dimensions of the perimeter. Finally, there's a building setback line shown along here, which is shown on all the building lots. It's not shown on this roadway because this was never intended to be a buildable lot, so it didn't need a building setback line.
And if you look to the north of Ninigret Avenue, do you see some setback lines there?
Yeah, there's building setbacks throughout the plat on all the buildable lots.
Now, would you compare the area in question being what we've been calling Spring Avenue Extension to the other roadways on the plat? And again, you can refer to Exhibit 1, otherwise known as Exhibit I.
Yeah, basically all the roadways are 50-foot strips of land, boldly outlined. When they come to intersections, they are open as they cross each other. Spring Avenue is such, Meadow Ave, Shamet Avenue, Ninigret Ave, even the public highway on the west side is shown essentially like that. What we're calling Spring Avenue Extension is identically drawn to all of the roadways on the map.
And would you place this strip in context of the subdivision as a whole? And again, I'll allow you to refer to Exhibit 1.
Yeah.
What was its function is what I'm trying to say.
In each of the deeds of the various lots, there's a provision that says, by accepting a deed in this subdivision, you don't get to go to the beach wherever you want to on the remaining land of the owner. You have to go on the right of way shown on the map. This right of way is the only right of way shown on the map. It's the only right of way to the beach for all the lots in the subdivision, other than those which actually front on the beach and which can access the beach over themselves.
And what was your understanding of the overall purpose of this community?
It was a residential community.
Was it a summer colony?
Yes, at the time, and it still is pretty much a summer colony, I think, although there are many more year-round dwellers than there were surely back in these days.
Was it a beach resort?
Yes, sir.
And do the streets in this subdivision connect directly or indirectly to the public highway system of the town of Westwood?
They do. The road labeled highway to the west of the subdivision, it is a public highway.
And all the roads allow access to that? All the roads have a connection to that, directly or indirectly?
Directly or indirectly, yes.
So how would you summarize the depiction of the disputed strip based on your observations of the face of the plat itself?
I would summarize it as a public highway, as a highway shown on the plan, similar to Shamet Avenue, Meadow Avenue, Minigrid Avenue, and the portion of Spring Avenue that runs north of it. It's as much as a highway as any of those.
And what name would you give it?
I just call it Spring Avenue, but people subsequently named it Spring Avenue Extension. For me, it's the piece of Spring Avenue that runs between Minigrid Avenue and the shore and the beach.
Do you have an opinion to a fair degree of legal certainty as to the legal significance of the 1920 plat?
Yes, sir.
And what opinion do you reach regarding the 1920 plat?
My opinion is that the recording of that map was an incipient dedication of the roadways to the public.
Is it ambiguous?
I don't think so, no.
What is the consequence of it being an offer of dedication?
It can be accepted by the it can be accepted by the public in various ways. One is public user, the other is by an act of the town of Westwood.
And when you say user, is that a word that maybe a layperson might call usage?
It means whether you use it, yeah.
What happened to this plat in 1921, if anything?
It was recorded.
And was it used for deeding out?
Yes, lots had previously been deeded out, referring to previous iterations of the maps of the area. Following the recording of this map, and actually even beginning with one deed prior to the recording of this map, most of the following deeds for a longer period of time refer to this map.
And showing you proponents exhibit 3. I don't have a placard to match this, or not be very interesting. Can you tell us what that is?
That is a deed from the Weekapaug Beach and Land Improvement Company to Phoebe W.P. Buffum of 3 parcels in the Weekapaug Beach. Parcel number 1 consists of lots 74, 75, and 76. Parcel number 2, 69, 70, 71, and part of 72. And parcel number 3, lots 82, 3, 4, 5, and those are all as and then parcel number 4 is a triangular parcel, not a lot number, and they are referred to as shown on the map made by Thomas Mackenzie, dated August 27th, 1920, filed or to be filed with the office of the town clerk. As of the recording of this deed, The plat had not been filed.
Okay, but is that plat that's being referred to in that deed, is that the same plat that we've been discussing?
Yes, it's the Mackenzie 1920 plat that we've been discussing.
Okay, which is Exhibit I, otherwise known as Exhibit 1. Okay, thank you. So was this plat used for deeding out?
Yes,
Okay, is what you're holding there as Exhibit 3, is that an example of that?
that's an example of of several lots on this plat conveyed by specific reference to this plat.
Is there anything in the language of that deed about rights of way? It would be in that addendum clause. I know.
Okay, yeah, basically it grants the lots the right to use the roads shown on the map, but it specifically states, but nothing herein contained shall be construed to grant or convey by implication or otherwise any right of way to the beach across or upon the lands of the said party of the first part, except by such roads or paths as are now or may hereafter be made and opened according to law. And then it goes on further to prevent, and not to prevent the Weekapaug Beach Company from doing certain things that aren't particularly relevant here. Basically, what it says is to the owners in those plats, you get to the beach over the roadway shown on the plat. And that's the only roadway shown on the plat to the beach.
That being what we're calling Spring Avenue Extension.
Yes, sir.
Okay. So again, showing you Exhibit 1, otherwise known as Exhibit I. You're telling us that where I'm putting my finger now, which is Spring Avenue Extension, so-called, is that way that's being referred to in that.
Yeah, at the time,
Yes.
it's the only way laid out according to law.
Thank you. Is there anything you can say about the sequence of the recording of the plat in that deed?
Well, the deed was recorded prior to the plat being.
But what was the legal effect of that?
The deed was lawful. It referred to a plat that wasn't of record. You can do that perfectly, and the plat never has to be recorded. Early in the process, there was references to an 1884 plat that was filed or to be filed, and that was never filed, and those lots are still good. And the subsequent recording of the deeds simply makes it easier to figure out where the lots were. The poor guy was trying to examine the title and can't find the map that wasn't recorded.
You mean the subsequent recording of the plat?
Yeah, the subsequent recording of the plat.
But in this case, the plat was recorded.
It was recorded about a year later, and then you find this deed report and you know just where the lots are.
Okay. So when was the offer of dedication made in this case?
The offer of dedication was made with the recording of the plat.
I'm going to take Exhibit 3 from you and hand it to Mr. Hartman and ask that it be admitted into evidence in full.
Stipulated.
Thank you, as far as I admitted in full.
And showing you what has been marked as Exhibit 4. I think you'll agree that it's a deed from 1926.
The deed dated January 26, 1926, recorded February 2nd, 1926, from the Weekapaug Beach Company to Frederick G. Buckham Jr. And it's lot 56 and a portion of adjoining lot on that same Mackenzie plat.
Okay, the same plat that we've been referring to?
The 1920 Mackenzie plat that we've been referring to.
Yes, okay. And is there anything about this particular deed that you'd like to point out to the subcommittee?
Yeah, it's the description of the property. Oftentimes in these deeds, the description referred only to the plat number and didn't refer to necessarily to the abutting properties. This does. It starts out as all that certain parcel of land on the map dated and recorded in the office of the town clerk, shown as lot 56, the same being 74 feet on the rear or westerly side thereof, 267 feet on the northerly side thereof, extending to the west line of Spring Avenue. Thence in a curved line along the westerly line of Spring Avenue, approximately 80 feet, to a point located on the west line of Spring Avenue at the northeast corner of lot 56 on said plat. Thence westerly on the southerly side of said lot.
Thence westerly.
Sorry, ma'am. On the southerly side of said lot 56, 234 feet from the point of the west line of Spring Avenue at the southeast corner of lot number 56 and the northeast corner of lot number 55, excuse me, to a point located at the northwest corner of lot number 55 and the southwest corner of lot number 56. He said several distances more or less.
Okay, but the key thing here is that it uses Spring Avenue by name as a boundary.
It uses Spring Avenue by name as a boundary.
And why is that significant?
That's significant because subsequent cases, a subsequent case allowed a dedicated right of way to expire over a period, if not accepted over a period of years, unless there were conveyances made specifically bounding the lots conveyed on that highway.
Okay, so this would fall into that exception.
They fall into that exception.
Okay, I would ask that exhibit 4, whatever exhibit number we're up to, yes, 4, be admitted into evidence.
We'll stipulate to it.
Thank you. Of course, I admitted in full.
Now, I'm going to approach you and hand to you what has been marked as Proponents Exhibit 5. And can you tell us what that is?
That is chapter 538 of the January 1923 section clause of the state of Rhode Island, titled "An Act to Regulate the Dedication of Private Lands by the Owners thereof as or for streets or other ways for public travel in the town of Westwood."
Okay, so in the very title, it refers to the word dedication, uses the word dedication.
Yes, to regulate the dedication of private lands.
And is the amendment included as part of the exhibit 5?
Yes, it was amended as chapter 746 of the January 1925 session of the public laws. That was called an act and amendment of chapter 2299 of the public laws passed at the January session 1922, entitled "An Act Authorizing the Town of Westwood to Enact Zoning Ordinances," and of chapter 538 of the revised public laws passed at the January session 1923, entitled "An Act to Regulate the Dedication of Private Lands by the Owners thereof as or for streets or other ways for public travel in the town of Westwood."
Okay, and I think it's fair to state that it's section 3 of the latter statute that amends the 1923 statute, correct?
Sections 1 and 2 represent, do not. Section 3 does, it's the only section that does.
That amends back to,
That amends the ordinance we're talking about.
the statute we're talking about, okay. Now, in your own words, would you please describe the overall statutory scheme?
Our Supreme Court has pointed out even recently that dedication and acceptance cases are very difficult and very expensive.
We know that.
I think no one here will dispute that. The town of Westerly apparently was trying to control that as far back as 1923. Well, this statute set up a procedure whereby if you wanted to dedicate a parcel of a roadway in the town of Westerly public use, you had to go through a procedure originally before the town council and the zoning board. And the highway commission, I mean, but the very quickly amended, so you had to go before the zoning board and the highway commission. What it basically was set up was a way to basically determine that a highway, a roadway to be offered for dedication had indeed been accepted by the town without requiring an act of the town council and without requiring subsequent inquiry into the nature of a public user.
And how did the statute go about doing that in your understanding?
It required the owner of the property to submit a plan to originally the town council, but while in the period we're talking about, to the zoning board. That plan was required to have a profile of the proposed street and shall show its location, width, which shall not be less than 50 feet, and grades, and the location and grades of all connecting streets, and drawn to such scale and upon such material as the zoning board may require with satisfaction. Once that was submitted, the zoning board refers the plat to the Board of Highway Commissioners for its report on the nature of the plat. Once it's received the report from the Highway Commissioner, the zoning board would then determine if such street of ways are reasonable both in the location, widths, and grades, with due regard to both public and private interests involved. And then if it was, the zoning board would approve it. If the zoning board found it wasn't, it wouldn't approve it.
What form did that approval take?
It's historically taken the form of a zoning board stamp on the plat.
What does the statute call that? What word does the statute use?
It says that the zoning board shall approve the same, let me see. And upon such approval shall endorse and certify the fact of such approval by said zoning board on each such duplicate, but shall not file or record the same until requested by the owner of the lands and until the fees therefore are paid.
Okay, so it uses the word endorse.
It says endorse and certify.
Okay, thank you. You mentioned profiles. Well, let me ask you this. Is there any record keeping requirement under the statute?
Not under this statute.
Okay, is there any call for recordation eventually?
No, all that's contemplated being recorded by the statute is the plat that's been presented.
Okay, it's called for recording of the plat.
Yes,
Okay, so there's record keeping of the plat.
yeah, yes.
And that plat would bear the endorsement.
If approved by the zoning board, it would bear the endorsement. It could be rejected by the zoning board, in case it wouldn't.
And if it was rejected by the zoning board, could it be recorded?
Actually, according to this, actually, you would think it could, because, if it were, it would not create public roads. Or roads open to the public. I think the clerk wouldn't have recorded it. Then section 4 allows that any person aggrieved by the zoning board action can appeal it to the Superior Court. Section 5 basically says that upon the filing or recording of said plan, pursuant to the provisions hereof, such street or way shown thereon shall not be open to the travel to the public until certain the roadway is cleared, excavation work brought accurately to the subgrade as the Board of Highway Commissioners may require, and all intersections, the streets rounded and granite bound set at all angles, curves and corner of such street according to the direction and approval of the Board of Highway Commissioners.
I'm going to just object to the extent that the witness is omitting words from section 5 that he's cited.
And then following this approval, the Board of Highway Commissioners if this procedure is not applied with, the Board of Highway Commissioners can close the roadway shown off of the public highway as not safe for travel.
That last statement that you made, which requirements within section 5 does that refer to?
That refers to all of the requirements in section 5.
How about the requirement about removal of stumps, rocks?
All the requirements in section 5. Any requirement shown in section 5 that refers to the Board of Highway Commissioners could find any one of those not satisfactory and close it off if it chose to.
Objection.
Well, in your view, just to focusing on that very last sentence of section 5. What is the import of that in terms of the authority of the highway commissioner?
The highway commissioner is exclusively responsible for administrating this section of the statute. Yeah, section 5 of the statute.
All of section 5?
All of section.
Objection.
Mr. Barsadi, just again state the basis for your objection.
Sure. The testimony contradicts the plain terms of the statute.
Thank you, Mr. Barsadi.
Then the statute goes on in section 6 to say that upon filing a recording of the plan, which would have been authorized by the stamping by the zoning board, and compliances with the provision of section 5, which would be, in this case, witnessed by the stamping of it by the Board of Highway Commissioners, such street or way shall be thenceforward a public highway to all intents and purposes, and be liable to be opened by the Board of Highway Commissioners of said town in the same manner as highways which are laid out by the Board of Highway,
Excuse me, such manner, slow down a little bit.
as highways which are laid out by said Board of Highway Commissioners. But it provides further that the town shall not be liable to repair or maintain the roadway which has been laid out as that public highway until such time as the Board of Highway Commissioners shall specifically decree and order same shall be repaired by the town. But this allows the town to create the roadway as a public highway available for the public, but yet not have the duty to maintain it.
Thank you for that explanation, but I would like to go back a moment to when we're talking about the highway commissioners exercising authority under section 5.
Yes, sir.
And you understand that I use the highway commissioners and the Board of Highway Commissioners interchangeably.
I understand that.
Okay.
I probably do the same.
Okay. Did the highway commissioners have the authority to disapprove of the road
Yes,
or of a set of roads?
yes,
Did they have the authority to approve of a road or set of roads?
yes.
I'm going to submit exhibit 5 to Mr. Hartman and ask that it be marked in, say, a full exhibit.
Mr. Barsadi, is this stipulated?
We'll stipulate to the statute, yes.
Thank you, Mr. Barsadi.
Now, before we get to the 1939 plat, I'm going to show you a deed. And it's noted as Proponents Exhibit 6. It also corresponds, I believe you'll find with joint exhibit J, as a matter of fact, in terms of J in that booklet there, and just confirm that they're the same thing.
They are the same. It's a deed in the Weekapaug Beach Company for the town of Westerly, dated January 31st, 1939, and recorded February 3rd, 1939, in book 58 at page 519 of the land records.
Okay, and this deed is a deed of a roadbed, I understand?
It's a certain strip of land 50 feet wide to be used for highway purposes, located at Weekapaug in the town of Westerly, and delineated shown as Spring Avenue on the plat on the 1920 Mackenzie plat. Then it provides a meets and bounds description of the specific roadway. Meets and bounds description being basically so many feet in this direction, turning such and such an angle, that basically draws the roadway in words.
So is there any plat that this refers to or incorporates by reference other than the 1920 Mackenzie plat?
No, there isn't.
Okay. So is this deed the basis of your opinion with respect to the portion of Spring Avenue that is the subject of this case?
No, it isn't. The reason it isn't is because this deed does not describe that portion of Spring Avenue. It describes the portion of Spring Avenue running, well, to the north only, and not specifically as shown on the Mackenzie map.
There's some deviation?
There's some deviation, but it essentially follows the track.
Okay. Well, you say you follows the track. Can you, and I understand that it doesn't represent it exactly, but using the Mackenzie map that we're already familiar with.
Starts here on the north side of Ninnegrid Avenue, goes up to approximately here.
Approximately here being, if you can.
The northerly boundary line of the northernmost lot shown on the Mackenzie plat.
Okay.
Yeah,
And I believe that that would be lot 66.
I think you were.
Okay, thank you. I'm going to ask that this be admitted. It's already been admitted as exhibit J, this duplicate, just for completeness of the record, is exhibit 6.
Thank you. Process
Stipulated.
then it is 6.
Now, showing you what's been marked with exhibit 7 to the effect of the 3-volt function. I don't think you can see the 7, but it's there, or was there. And I'd like you to that and tell us if you recognize it.
I do.
And looking in your little folio, would you compare it to exhibit L and tell me if it's the same thing?
It is the same.
And looking at the placard that's now on display, would you compare what you're looking at to the placard?
It's a reduction in size of the placard, but it's the same map.
Okay. And which most corresponds with, in size, with what's actually in the land records?
Oh,
The placard or what you're
The
holding?
placard, this is
Okay.
nowhere near the size of what's in the land records.
Okay, what you're holding is nowhere near the
Right,
size.
the placard is much closer.
Right, okay. And could you describe the significant features of that?
Well, it does a couple of things. It shows that Spring Avenue ran a little bit further north to the deeded portion than that I just described, that it goes up to an angle line here above lot 66. And it also contains a stamp by the zoning board, by the Board of Highway Commissioners.
And while you're still holding that in your hand, I'm going to show you plaintiff's proponents exhibit 8 and ask if that how that corresponds with exhibit 7.
Piece of paper you handed me is an enlargement of a very small portion of the placard, including this stamp, and which can be said to read, Town of Westerly Highway Committee approved July 3rd, 1939 by Mr. John Pucci, Mr. Howard Burdick, and then this separate stamp that says approved date September 13, 1939, Louis J. Rossi, Secretary of the Zoning Board.
Okay. And looking at the placard that I'm holding here, could you just outline quickly what you were just talking about?
Yes, Town of Westerly Highway Commission. Approved January 3rd, 1939 by Mr. John Pucci, Mr. Howard Burdick. Down below, approved September 13th, 1939, Louis J. Rossi, Secretary, Zoning Board.
Okay. And what I'm holding here corresponds with what you're holding there is exhibit 8, which is.
It corresponds with it, and it is an enlargement of the portion of the Weekapaug Beach map revised April 1939, and which we're referring to here.
Okay, so it's an enlargement of exhibit 7.
Enlargement of a portion of 7.
Okay,
Yes.
thank you. And what is your understanding of well, let me back up a second. What is your interpretation or your understanding of this of the process that this plat was undergoing? And where was the source of that process in your understanding?
This plat was submitted to the zoning board pursuant to the provisions of chapter 238 of the general laws, which we discussed earlier. As
538.
538, by the owner of the property, basically creating lots to travel across by be dedicated to the public and potentially to be opened up for the public.
Objection, lack of foundation.
And when you, I think just a technical correction, you just said lots to be
Highways.
highways.
Roadways.
Okay. Does this plat, what hallmarks does this plat bear that correspond with chapter 538?
The hallmark that bears are the stamping by the Board of Highway Commissioners, stamping by the zoning board. Prior to the enactment of 538, zoning boards wouldn't stamp plats filed by developers, nor would the Highway Commission. The only reason for those stamps is because of the requirements of chapter 538.
Now, when you say prior to chapter 538, you're saying prior to 1923.
Yes, sir.
Okay, that wouldn't have happened.
No, because there was no provision for it. You won't find maps that have those stamps.
And the general zoning laws of the town of Westerly, such as, are you familiar with the general zoning laws of the town of Westerly at that time, more or less?
I don't know exactly when they were adopted, but So I really can't say. I haven't verified, so I'm not real familiar with them.
Right, okay, but typically, you're familiar with zoning laws in general, correct?
Yes, sir.
Like dealing with like setbacks, heights, density, things like that,
Yes, sir.
correct? And lot size, side yard size, and so forth. Is that correct?
Yes, sir.
Okay, do those involve the some kind of highway commission approval, that will speak?
No, sir.
Okay.
Excuse me.
Is there who submitted this plat?
Objection, foundation.
The chapter 538 required that any plat to be considered under its provision be submitted by the owner of the property that's the subject of the plat.
And would that have been the Weekapaug Beach Company at this time?
Objection.
Would have been well, at some point, the Weekapaug Beach and Land Improvement Company changed its name to the Weekapaug Beach Company. They're the same entity, and it was the owner of this property, whichever it was at the time it was submitted in 1939.
How do you know that it was not submitted by the town of Westerly?
Town of Westerly has no authorities to submit it.
And how do you know that?
Statute doesn't allow, statute specifically says shall be submitted by the owner of the property. Goes on further to say that it shan't be recorded until specifically approved by the owner of the property, even if the zoning board and the highway commission both stamp it. The owner has a chance at the beginning to start the process, and if he doesn't like the results, up until he records it, can change his mind, even if the highway commission and the zoning board have both acted.
Based on your review of this plat, was the highway commission satisfied that stumps and rocks had been removed, or that the rather that the roadway was clear of stumps and rocks?
Yes, if it hadn't been, it wouldn't have stamped it. There is one idiosyncrasy here that it stamped it before the zoning board. But you've got to remember that these roads were first constructed in 1884, and they've been being used at this point for 55 years. So they were substantially created already. It wasn't a situation where you're bringing a new plat to the highway commission or to the zoning board saying we want to improve it, and then you're subsequently created. They were looking at a plat that showed what was essentially a fait accompli, something that had been in effect for many years. The only substantial change being made was the slight relocation of Spring Avenue above Niagara Avenue.
Now, was this plat recorded?
Yes, sir.
Is there an indication on the face of the plat that it was recorded?
Yes, sir.
You can use your laser pointer.
Now, it's right there. And what it says is received and filed in the town clerk's office, Westerly, Washington County, Rhode Island, on October 14, 16? Yeah, it is 16, 1939 at 10:50 a.m. attached. And then there's a signature and it says Deputy Town Clerk. I can't read the signature.
So did the clerk have under the statute, and maybe I would refer you to section 1, what was the function of the clerk?
Clerk had two functions. First, it would have been referred to the highway commission, which was done by the town clerk, or was the council, but would have been done by the zoning board after the amendment. So they wouldn't have that. The clerk's sole function was to approve it and author and record it once the highway commission and the zoning board had stamped it, and the owner then specifically requested that it be recorded.
Was the clerk allowed to accept a plat such as this for recordation without the zoning board approval. Under section 1.
No, not section 1.
Um. Based on your professional evaluation, do you have an opinion to a reasonable degree of certainty as a title attorney as to the significance of this plat with respect to the area that we've been sometimes referring to as Spring Avenue Extension?
Yeah. What the Supreme Court has told us again and again is that you must, when you're interpreting a plat, you must look at all of the plat as an entirety. You can't, you've got to look at everything on the plat. In this case, we have a plat that shows private roadways and a statute that describes how those private roadways can be not only dedicated to the public, but can be accepted by the public with or without a maintenance obligation or with a maintenance obligation. The stamping of this map by the Highway Commission and the Zoning Commission, the subsequent recording results in a dedication and statutory acceptance of all the roads shown on the plat.
And would that include the subject of this case?
That would include the subject of this case, which is one of the roads shown on the plat.
Now, based on this plat, would you say that the town of Westerly had or has an obligation to maintain Spring Avenue Extension?
The plat doesn't show that. What would show that would be a subsequent decree. And that would be the same thing for Shawmut Avenue or Meadow Avenue or Neighborhood Avenue. The previous deed we referred to showed that the town acquired the fee interest, which is distinguishable from a right-of-way interest in the part of Spring Avenue running north of Neighborhood Avenue. So they owned it, it was theirs. The others, without a specific decree of the Highway Commission, the town would not have had an obligation to maintain it. Doesn't say the town couldn't assume that obligation had it chosen, had it previously already begun. For instance, they had begun maintaining Neighborhood Avenue so that you get from there to the Weekapaug Inn.
So if a road is not subject to yet, let's say, the town maintenance, what rights does the public have in it?
In this case, with these roads, may I see the statute again? Because I'll tell you exactly what it says.
Thank you. Okay, thank you, Mr. Hartman, for giving me plaintiff's opponent's 5, which I'm handing to the citizens.
In section 6, that upon the filing or recording of such plan in compliance with the provision of section 5, such street or way shall be thenceforward a public highway to all intents and purposes. So the public would have the right to go across that highway just as if it was a public highway that the town was maintaining. The town wouldn't have a maintenance obligation, even though the public had the right to use it, until there was a specific decree and order of the Board of Highway Commissioners.
So it could be public for the purposes of passage, but not maintenance.
Public for the purposes of passage, but not maintenance, yes.
And how does the deeding of Upper Spring Avenue that we saw in a prior exhibit, in Exhibit 6, how does that affect this opinion?
It doesn't affect the opinion at all regarding Lower Spring Avenue. It changed, but basically it affects only Upper Spring Avenue.
I would like to return to Mr. Hartman Exhibit 5 and also move for the admission in full of what has been marked as Exhibits 7 and 8.
Won't object.
Thank you, Mr. Conrad. Thank you, Mr. Rubin. Mr. Rubin, I just want to check with our stenographer. Can we break? How are we doing?
If you're gonna take one, now is the time thing.
Is this a good point to break, Mr. Rubin?
Would be.
Okay.
Thank you.
Mr. Chair,
Sure, take about 7 minutes.
okay, let's return to
I'm looking at the clock. I mean, whatever, 5, 7 minutes.
eight 15. Is that what we're looking for, Mr. Chair?
Yeah.
Okay.
Get them what you need to do.
Before we get back to it, I just want to address a procedural and timing matter. We're looking to wrap this up around 9 o'clock, so I think we give about another hour to witness testimony, because we can go over a little bit, but we really do have to be wrapping up around then. Mr. Farside, of course, has an opportunity to cross-examine. If we don't get that tonight, you'll have the opportunity at the next meeting to do so. But I'd ask that the council bear that in mind, that we're looking to get this done in about an hour now.
Thank you.
Okay.
Anything? I'll jump right in with then.
Okay.
Go along. Can I have Exhibit 5? That's the statute.
Yes, Mr.
Good. And showing the witness Exhibit 5. And I also like to get, if I may, Exhibit 6, which was that deed, the deed of Upper Spring Avenue. Thank you. I'm going to show you both again. So I'm sorry for jumping around in time, but I wanted to ask you, is the deed of Upper Spring Avenue and this plat that we've been referring to, is Exhibit 7, are they simultaneous?
No, sir.
Okay, what was the date spread between them roughly?
The deed was recorded February 3rd, 1939. The plat we're referring to was recorded October 16th, 1939. So that'd be about 8.5 months later.
Okay, and does the deed refer to this plat?
The deed refers not to this plat, but to the 1920s plat.
And does this plat have on it any reference to that deed?
No, it doesn't.
And I believe you said that index cards, what's the status of clerk's index cards when they index plats as part of the land records?
They're basically exactly what they say, an index. It is a tool to point you to where the map is.
Okay. Now, turning to that, back to the statute. Does the statute tell us anything about the process for that deed that was earlier back in February? I'm sorry for going out of sequence, but sometimes it happens.
Section 7 of the statute is the provision by which the town clerk can record a deed to the town of any land in the town which deed is made for the purpose of having the land described become a public highway.
And could the clerk accept a deed for the roadbed of a highway without obeying Section 7?
Without, no, the clerk would have to obey Section 7.
Okay, Section 7 was mandatory.
Yes,
It was the only way to record a deed.
yes.
So this deed that you're looking at, which I believe is Exhibit 6, that deed would have had to have gone through Section 7.
Right, the deed was submitted for recording. The town clerk's the office to record. The town clerk's ability to record the deed, since it was a deed to the town for road purposes, was controlled by section 7 of the ordinance, of the statute.
And the clerk had to make an evaluation of the deed, correct?
Yeah, basically, the clerk would not record the deed unless the council shall have first accepted the deed, provided, however, that this provision shall not apply to any deed of any land that is shown as a street or way and is open to travel or otherwise dedicated for public use on any plan then on file or recorded in the office of the clerk. So the clerk could have looked at the 1920 plat, looked at the deed and recorded it for that reason. The clerk could have also found an acceptance of this deed by the town council. One of those two, the clerk would have done.
Okay, so there are only two paths or two means by which the clerk could have accepted this deed.
Yes, sir.
Okay, and I'm going to ask you to assume that later testimony in this case will show that there was no prior town council approval.
Okay.
Now, assuming that that is the case,
Assuming that is the case, and the clerk recorded the deed, it would have been because it was shown as a street or way and is open to travel or otherwise dedicated for public use on a plan then on file or recorded in the office of the clerk. That plan would have been the plan referred to in the deed, the 1920 Mackenzie plan.
okay, and showing you that 1920 Mackenzie plan, which is Exhibit I, also Exhibit 1,
Yes,
assuming the assumption that I just said before, namely that there will be testimony in this case that there was no town council prior approval
of the deed.
of the deed, what determination did the clerk necessarily make about this plat?
Determined that Spring Avenue was shown on that plat as a street or way or and is open to travel or otherwise dedicated for public use.
And as shown on this plat, what is the difference between Upper and Lower Spring Avenue, as shown on this plat here? That's being Exhibit 1.
Looking at it, as Spring Avenue runs to the south, it splits and forms. One side goes to the east, one side goes to the west. The portion that goes to the east was not deeded to the town. It looks as though the portion that was the tract of the road essentially follows that eastward line and then continues to move along Spring Avenue.
But I think your earlier testimony at the very beginning of the evening was to the effect that Upper Spring Avenue and Lower Spring Avenue were depicted the same on this earlier plat. Correct?
It's all shown as Spring Avenue,
Okay, thank you.
but that doesn't have anything to do with the part that's above the roadway,
Right.
above Ninnegren stuff.
So again, assuming that the clerk, that there was no prior town council approval, the clerk made what determination with respect to the earlier plat?
The clerk made a determination that the land described in the deed was shown as a street or way and is open to travel or otherwise dedicated for public use on a plan recorded in the office of the town clerk. And in this case, the plan she would have referred to would have been the 1920 Mackenzie plan,
Thank you.
which is the plan specifically referred to in the deed. You want to get this document?
I think I can take that and hand those two things, if you would, the deed and the statute.
Thank you.
Now, I'm going to move a little bit forward in time. There has been some discussion of a 1940 report to the town council. And in fact, I believe that you underwent a deposition, a second deposition that was specifically focused on that report, correct?
Yes, sir.
Okay. Does that report detract from the opinion that you have rendered here tonight?
No, sir.
Why not?
Well, first of all, it's not part of the land records. Second of all, it doesn't logically contradict what I've testified to this evening.
Please elaborate.
Do you have it so I can look at it, please?
It's actually, I do not. I hope that you recall your memory.
A board of public citizens petitioned the town council to identify public rights of way to the shore from Watch Hill to Weekapaug. The town council appointed a private committee to do just that. The private committee issued a report to the town council identifying from Watch Hill to Westerly platted rights of way that appeared to run to the shore. With the exception of 2 streets, which were public highways, every one of those platted rights of way identified by the committee was found on a plat recorded prior to 1920 in the land records. The plats of the Everett plats of Watch Hill, the B. Frank Clark plat, a couple of other plats, including the 1909 plat of Musquamaket Beach, were all identified. They were all plats. They were all lots that had been platted prior to the 1922 or 3 enactment of the statute related to the approval of public roads by the Highway Commission and the zoning.
So would the Spring Avenue extension, so-called, be listed on such a report?
You would think it would be, and as Mr. Parsons, excuse me, pointed out in my deposition, the citizen member of that committee was a man named Louis Rossi. He prepared the 1939 plan. He was familiar with the 1939 plan. They identified every platted right of way to the shore, short of Weekapaug. They didn't identify Weekapaug. And my feeling is that Mr. Rossi had already seen the 1939 plan go through the procedure and knew that it was already dedicated to the town. The others weren't. And what the town council did once it got the report was it directed the zoning board to do what was necessary to make those rights of way open to the public under section 538.
I'm going to go ahead and just ask Mr. Farside to state the basis for his objection on that.
And my objection was a cause for speculation.
Okay, understood. The objections noted, again, this is because this is an administrative proceeding, relaxed evidentiary rules, but your objection is so noted. I see that Mr. Conley's standing, so I'd just like to recognize him for.
Yeah, thank you. So I'm likewise respectfully placing an objection on the record at this time. It's referencing a document that's not in evidence, referencing a document that which there is no foundation. It's referencing to a deposition testimony that is not before the committee. I'm not suggesting that maybe rebuttal testimony might not be, but at this juncture, there's absolutely no foundation for the document that's being referenced by the witness. And so I respectfully, at this point, would object to any further inquiry in that regard.
Understood, Mr. Conley. So we'll take that. The subcommittee can take that into consideration. And again, it goes to the weight of the evidence. They'll take the comments from both Mr. Farside and Mr. Conley into consideration. if Mr. Rubin decides to continue this line.
I'm gonna move on.
Yeah, I appreciate that very much, since it's a document for which there is no foundation and it's not even an evidence. I appreciate that. Thank you.
So, moving along, I'm going to, show you this next item, and I will give you the exhibit, which had been pre-marked as proponents exhibit 9. And ask you to look at proponents exhibit 9, and then in your folio, can you compare it to exhibit K, which is a joint exhibit? Tell me whether they're the same.
The exhibit you've handed me is the same as the exhibit K in the portfolio.
Okay. And is it the same as the placard that you're looking at?
Yes, it is.
Okay. And if I may, by turning it to be sort of portrait style, if you will, is that orienting it so that north is towards the top?
Yes, sir.
And where would the area that was depicted on the 1920 plat be on this plat?
Yeah. There were lots on the 1920 map north of Shawmut Avenue. This is Shawmut Avenue. Most of the plat was south of Shawmut Avenue. Lots up to approximately here were also shown on the 1920 plat.
Okay. And what about the 1939 plat that we have been discussing? And I refer to the endorsed revision plat that was exhibit 7.
The plan you referred to the 1939 plat shows the same area as the 1920 plat.
Okay. So this area is more or less, most of it is to the north of the plat that we were just addressing, correct?
You see Shawmut Avenue here on the south of this plat.
Okay.
You see Shawmut Avenue here, essentially on the north. So only these lots
Overlap.
But to the extent that counsel testifies for the witness, I think that the witness should be allowed to.
Okay. Fair enough, but I'm just trying to move things along, but.
My objection remains.
And to be clear, Mr. Rubin, we want to give you all the time that you need, as well as the proponent, the remainder of the proponents with their witnesses and the objectors. So, take your time with your witnesses. If it so happens that we go beyond the hour that we discussed, we'll take up Mr. Priestley on direct again at the next meeting, and then we'll again have cross. So there's no need to rush through this. It's more important that it gets done right than it gets, done.
But so basically, the lots south of this line and north of Shawmut Avenue are shown on both plats. The 1920 plat and 1939 plat include substantial lots to the south. The lots north of this line are part of the original 1920 plat, but not shown in the subdivision. They're raw land, part of the same estate, but not included in the main part of the plan, the subdivision part of the plan.
And returning to this plat, which is exhibit 9, is this does this bear endorsements by the Highway Commission, the zoning board? And if it helps you, you can look at the placard.
Yes, it does.
Okay. And does this plan in any place on it include Spring Avenue extension, whether in the main plan or in an inset. And you're welcome to look at the plaque.
Yeah, no, there's an inset here, which is, you lay the plat back down, it's in the upper left-hand corner, right underneath the title block. There's an inset, and that shows Spring Avenue here, and the piece of land we're referring to, Spring Avenue extension, right here.
And is there a legend on that plan in that upper right? And I'll reorienting it.
I can read it from here.
But just so that, you know, the lettering is.
So just below the title block and north of and above the inset, there are 3 lines. They read, owners of lots shown on this subdivision have a right of way to the Atlantic Ocean over Spring Avenue extension, shown as a 50-foot right of way on insert plan. The insert plan being this little plan here.
And does that language detract from your opinion as to the status of Spring Avenue extension?
I don't think it does. I think the owners of the lots were acquiring a private right to the water and a portion of a piece of land in a summer residential community where access to the ocean is crucial. The fact that it had been dedicated to the public doesn't mean that it couldn't subsequently be abandoned by the public, so that a private right protects you regardless of what happens in the future.
So when you say abandoned by the public, what are you referring to?
The town of Westerly could, if it chose to, abandon interest in public roads. There are procedures why it can be done, and it has been done. It doesn't happen often, but it can happen.
And so and how does that language fit into that?
In the event that were subsequently abandoned, the owners here would still have a private right of access to the shore over the 50-foot strip, even though if it no longer remained a public highway.
Okay. And now I'm going to show you Exhibit 10, so marked. And I'm going to show you. Might as well show you Exhibit 11 while I'm up there. Thank you. We'll hold on to this for now. And ask you to look at Exhibit 10 and tell us what it depicts.
Are you going to show a placard of it or not?
I am.
Okay.
I'm orienting this toward the north. I'm sorry, not north. North would be this way. But I'll orient it so it's readable. Go ahead.
That is an enlargement of a portion of the plan we were just reviewing.
And what can you tell us based on that portion?
Well, for one thing, it shows that the owners of the plat knew how to distinguish between a private right of way and a road dedicated to the public. They show 50-foot wide roadways with no markings on them restricting them, but they show a private, a more narrow roadway running from a cul-de-sac on lot 183 towards what looks like the Weekapaug Inn. I'm guessing, and since it's owned by the bus, and that's specifically designated a private right of way.
And does it use those words, private right of way?
It says private right of way.
And now, looking again at Spring Avenue extension, so-called, as shown on this map, which is going back to Exhibit 9, does the word private right of way appear?
It says 50-foot right of way.
Doesn't say private?
Doesn't say private.
Okay. to any of the roads shown on this plat, whether overlapping with the earlier plats or not, indicate private, other than the one that you just addressed?
None of the ones other than the 15-foot private right of way leading to the inn.
Okay, and if you can quickly look at the next exhibit, which is, I believe 11, is that same inset plan that you've been referring to?
Yes, that is the inset shown on this map.
Okay, and is that inset the one that shows Spring Avenue extension?
Yes, sir.
Okay, I would like that these three exhibits be given into evidence in full, and they would be 10, 11, and 12.
I think 9, 10, and 11.
Thank you. 9, 10, 11, excuse me.
And I would ask, we have no objection on 9 and 10, but on 11, we'd ask that we stipulate that 11 shows an insert, or shows the insert that's depicted on exhibit 9, so that there's no confusion in the record that exhibit 11 depicts a standalone plat.
Yeah, that's correct. Mr. Forsythe stated it correctly. I agree with that. Other proponents? Okay,
Thank you.
thank you.
So to clarify, 11, we're stipulating 11 is an inset for 10.
That 11 is an inset from 9.
9, thank you.
Thank you.
Now, if you can still look at that placard, or you can look at the joint exhibit, what is the date of recordation?
December 5th, 1941,
Okay, and what historic event happened 2 days later?
Pearl Harbor.
Okay, and did World War II have any impact on Spring Avenue extension?
Sometime during the course of the war, the United States government requested an easement over Spring Avenue extension.
And who did they request the easement from?
They requested it from the owner at the time. And I don't know if that was the Wesley, I think that was the Wesley Beach Company, or the Weekabaug Beach Company by that time.
Okay, and in fact, if you go through that folio that you have in front of you, I think you'll find joint exhibit 1.
Are you talking about, no, that's not legal.
Joint exhibit
There's no joint exhibit 1, there's all
A.
letters.
A. I'm sorry.
A,
A. Very first one.
I found it.
Okay. Is that does that correspond with the testimony you gave us?
Yeah,
You gave us?
it's an easement from Weekapaug Beach Company to the United States of America of the right to lay, construct, reconstruct, operate and maintain lines of communication, including the necessary wires, cables, conduits, pipes, manholes, fixtures, and appurtenances on, under, and over the premises described in the town of Westerly, bounded on the north by Ninigrid Avenue, on the south by the Atlantic Ocean, on the west by Lot 17, on the east by Lot 18, as shown on the 1920s Mackenzie plat.
Okay, and
It goes on further to specify those rights, if you want me to read that.
right. No, not necessary. Is that in any way inconsistent with anything that you testified to here tonight?
No, because when a road is dedicated to the public in the manner we talked about and accepted by the public in the way we've talked about pursuant to the statute, all the public requires is an easement over the road, but the owner remains the owner of the underlying fee. And so if you needed an easement over that portion, you couldn't get it from the public town, which only has an easement for passage. You would go to the owner to get the additional rights in the fee that you're trying to acquire.
Okay, and can you just very quickly explain the terms fee and easement?
Fee interest is essentially owner of all the bundle of rights that are associated with a partial of land. wood on it, the right to build on it, minerals underneath it, to dig into it, to pass and repass, any rights and all rights that you can have in a parcel of land are included in the fee interest. The fee owner can convey portions of those rights. He can convey to a neighbor a right to pass across it, that would be an easement. He can convey to a neighbor a right to view across it, which would prevent him from building in a certain area. All the while, he can convey to the United States government the right to put lines on the property, which would, as long as it didn't interfere with any other easements that he previously granted.
Now, I think the next chronological thing would be exhibits 12 through 15, which I'll show you exhibit 12 now. First, the photo placard. And then I will actually show you the exhibit itself, which has been marked exhibit 12. And I'm also going to ask you to compare it to joint exhibit M. Can you do that?
The exhibit you just handed me and joint exhibit M are the same document.
Okay, thank you. And I been brought to my attention that the members of the subcommittee don't have the joint exhibits yet. Look kind of like the president, but everybody's agreeable to present them. How many copies for the 5? Okay. Allow the chair to distribute. These are the joint exhibits that have been agreed to by all parties. Now, this particular plat covers land to the north of the previous discussed plat.
Mr. Rubin, just to clarify, excuse me, Mr. Priestley, just to clarify, is this joint exhibit M we're looking at right now?
Yeah, this is joint exhibit M. Thank you.
Thank you, Mr. Rubin.
It shows to the what is the south, the right-hand side, certain lots that were created on the previous map. Then it shows Taylor Lane at its southern boundary, which was the northern boundary of the map we just referred to. So everything north of Taylor Lane is north of the previous map, and it's the remainder of the property that was shown on the 1920 map that was acquired by Taylor in 1884.
Okay, and it's oriented so that north points up. It would be like this, correct?
Yes, sir.
Okay, and so does this have an inset plan as well?
Yes, it does.
And does it display? Does it depict Spring Avenue?
Yes, it does.
And is there language on this plan that is like the language that we saw on the previous plan.
Once again, right below the title block, there's language that says owners of lots shown on this subdivision have a right of way to the Atlantic Ocean over Spring Avenue extension as shown as a 50-foot right of way on the instant plan.
So, does that language contradict your testimony here
No,
tonight?
the same explanation. These owners would want a private right of way too if they could get it.
And why would they need a private right over a public way?
It's better because the public way could someday be abandoned by an entity they couldn't control. And if they have a private right of way over it, it doesn't matter. They can still get to the ocean.
Okay. Very good. And I'd like to move along to a insert. Oh, by the way, does this have the stamp of at least the zoning board on it?
It has the stamp of the zoning board. It does not have the stamp of the Board of Highway Commissioners.
Was that necessary in order for it to be recorded?
Not for it to be recorded, but for the roads to be open to the public.
Okay. Now, I'm going to show you what has been marked as Proponents Exhibit 13 and ask you if that is a portion of this 1948 plat recorded in 1949 that we've just been discussing, which is, thank you.
That up for a second, please.
Yes.
It is the portion of the map shown essentially with Taylor Lane to the south, with a bare little bit of the lots, but it's a portion, it's this portion of the of this plat.
Okay, and is there, and if I can show you the exhibit that you're holding as in placard form, if I can just look at that for a moment. Being exhibit 13, so 13 being a portion of exhibit 12, would you comment on exhibit 13?
Well, 13 is the portion of exhibit 12, and it shows essentially Taylor Lane as a public road, a road running north-south of the public road, and a offshoot from Taylor Lane. That's actually Taylor Lane's running east-west. Pardon, not north-south. This is running north-south. There's an offshoot at the easterly end of Taylor Lane, which they similarly wide road apparently, similarly delineated on the mark on each side, but specifically marked private road.
Okay. Are any of the other roads shown on exhibit 12, which is this 1948 plan according to 49, are any of them marked private road other than this one that you're just referring to?
No.
Okay. And I'd like to you to look at that inset in particular, which does depict Spring Avenue, so-called Spring Avenue extension, and ask if on the inset Spring Avenue extension is marked private.
You're talking about this exhibit?
Yes.
There's no inset on this one.
That's correct. I'm going back to it that well.
No, Spring Avenue, what they call Spring Avenue extension is referred to as 50-foot right of way. And then it says insert showing right of way to Atlantic Ocean. Let me use a scale.
Okay, but nothing about private.
Nothing about private.
Okay. And while you still have these other exhibits there, I'm going to show you what has been marked as exhibit 14 and ask you if that is a portion of exhibit 12, which is the 1940s plan. Yeah, very good.
The exhibit you just handed me is approximately this portion around Meadow Avenue and North Million in the area marked reserved. And lots running from 256, 216, 215, and 211, and 240, and a little bit of the surrounding area shown on this plan.
Okay, and that it being the more northern portion.
The
because
northern
north-
portion of the,
Just being north.
yes,
Okay, okay. And is what I'm displaying to you now, and I'm gonna hand you in a moment, I did hand you exhibit 14. Is this is this placard a reproduction of exhibit 14?
yes, sir, right down to the handwritten marks on it.
Okay, and what word do you see on a portion of the most northern
You
road?
see a strip of land here blocked off from North William Street with a bold line, and it's marked reserved. It doesn't have a lot number.
And what is your conclusion regarding that segment of the street?
That the owner of the property reserved that as a potential roadway to land to the north. Whether or not it owned the land to the north, and I couldn't opine about that, but as a potential roadway for future development, but
Okay.
not a roadway as yet.
So was it public?
No, sir.
That word reserved. Does that appear on the inset portion of the exhibit, which is we're going back to
This insert,
no, not that one, but rather here. Because we're going back to this exhibit here, which is the
this insert.
1948 plan. So again, I'm returning to the inset on exhibit 12.
Reserved does not appear, but it should, because this piece is shown, so that's not very well drawn.
Right. But it doesn't appear with respect to Spring Avenue extension, does it?
Oh, no, that's already developed.
What is your opinion about the roadways that appear on exhibit 12, other than the one marked reserved and other than the one marked private way?
You're referring to North Williams Avenue, South Williams Avenue, and the portion of Meadow Avenue running from North Williams Avenue to Taylor Lane. Those are private roads. They were never accepted by the Highway Commission. Taylor Lane, which runs along the bottom, is a public road. It was by its acceptance and delineation on the prior plan.
Okay. Did they have the potential of being public roads?
They could have been, yes, but they would have had to have the zoning board approve them pursuant to 538.
You mean the Highway Commission?
The Highway Commission, the zoning board didn't approve.
Okay. And that and you don't know whether that happened or not?
From reference to the map, I would say it didn't, because if it had, it would have been stamped on the map. I don't know if subsequently.
Right.
There was another plat recorded which did, but as of this plat, it did not happen.
I'm gonna ask that these exhibits, of which there are a total of 3, being exhibit 12, exhibit 13, and exhibit 14, all be admitted in full.
And Mr. Rubin, I just ask for clarification. Are those exhibits all portions of the joint exhibit M?
Yes, they're all portions of Joint Exhibit M.
Okay.
One is Joint Exhibit M, and the other 2 are portions.
Thank you. Mr. Parside?
No objection.
Thank you.
Okay. And then, along the same line, again, a portion of Exhibit M. I'm going to show you this and ask you if this is the inset map that appears on Exhibit M. And that item is labeled Exhibit 15. Components 15.
Yes, it is.
Okay, then I would ask that Exhibit M, Exhibit 15 be submitted in full as a portion of Exhibit M.
Mr. President,
No objection to the extent it's a portion of Exhibit N.
thank you. All admitted in full.
If I may confer with counsel. At the beginning of your testimony, I never showed you your resume, basically because I numbered it last. But here it is, Exhibit 17, and I would like, I'm skipping Exhibit 16, and I would like you to explain, not explain, but state whether that's your resume.
It is.
Okay. It was prepared a few years ago when this case began.
Yes, sir.
Okay. I would like Exhibit 17 to be admitted in full.
No objection.
Thank you, Mr. President. Admitted in full. Thank you.
Now, Mr. Priestley, I want you to assume a fact. I want you to assume that there has been no official abandonment of Spring Avenue Extension
By the town of.
by the town of Westerly.
Objection assumes facts not in evidence.
And with that assumption in mind, can you state your opinion as to the status currently of Spring Avenue Extension?
It's a public highway, open for access by the public. It will remain so until we're abandoned by the town of Westerly. Assuming that it has not been, it remains a public highway.
And have you seen anything that resembles an abandonment in this case?
No, but I haven't looked for it either.
Right, okay. Now, what, in your understanding, is the status in terms of Westerly's maintenance obligations?
I don't see anything in the record that I found that provides for a maintenance obligation by the town of Westerly.
And I'd like you to consider the other streets in the neighborhood commonly known as Weekapaug, as shown on these various plats. Why would it be that some of those streets appear on town lists as private?
What town lists?
Town highway lists as private.
It's the highway department list.
Highway department list, yes.
I would assume that the highway department differentiates between roads it has an obligation to maintain and roads that it does not have an obligation to maintain. And several of the roads on the map.
Would it help if I were to show you the 1939.
Let me start real quick. None of the roads on the map, with the exception of Upper Spring Street, which they acquired in fee, show in the record we've discussed any obligation on the town of Wesley to maintain them. None of them. Some of them, the town may have assumed that obligation, but in the record we've discussed, none of them show a decree by the highway department requiring the town of Wesley to maintain them.
I can confer.
They're in this room.
I can't do it. Maybe I can.
It's coming on the front.
35% of the votes in, but still. 51, 39, still. I know.
You say first. Wayne,
You're back in New York. Look at all the other candidates, not even a percentage. He add his to Cornwall's, it's still not close. Actually, Virginia, I think New Jersey, they're all.
If I can have just one more moment.
Sure.
I have no further questions. Thank you.
All right. Let's wrap it up.
I got it.
Stop. Oh.
Mr. Farside, we're looking at the time right now. And I think to have a fully robust cross, it might make sense to go to the next meeting, but I want to hear from you as to whether you have any opinions on that.
That probably makes sense, as I probably have 30 to 60 minutes worth of costs.
Okay. Subcommittee members, do we have any consideration on how to proceed for tonight with that regard as far as witness testimony?
Well, my opinion would be to end it now and afford him his full opportunity to cross-examine, because I don't want to have a time restraint and have him stop with maybe 10, 15 minutes left or something like that. So,
Okay, so in that case, we'll start off the next meeting directly with Mr. Farside's cross-examination of Mr. Priestley, and then we could move on to the next witness for the proponents. We do have a couple housekeeping matters to address.
Just a question, is this going to be the fourth Tuesday in November or some future meeting?
We would have to discuss among the subcommittee, but I believe it'll be a different meeting than the fourth Tuesday. I think that's going to be reserved for the regular order of subcommittee, right-of-way subcommittee. So with that in mind, I think we can move on to the next agenda item, Mr. Chair, if that's what you're pleased to do, which is scheduling the future hearing dates. Unless there are any questions that the proponents or opponents have at this time.
Not at this time.
all right. And I just think it's, staff is gonna, Jeff, you jump in. Staff will check availability as to a venue and throw some dates out to, there's a lot of people that we have to get schedules matched.
Thank you, Mr. Chair. We will look to this venue for available times. We know that there are other activities occurring in this building, but we'll coordinate with this building, your schedules and the attorney's schedules so that we can schedule a meeting as soon as possible in this venue.
I would just voice that the witness, who is probably indispensable, will be unavailable essentially from the 6th through the 16th.
Of
December, which happens to be the same dates that I happen to be unavailable. If we could just avoid that time,
Okay.
That's inescapable.
Well, staff will reach out to all parties first thing in the morning and start working on a new schedule.
All right, anything else to come before the subcommittee? I entertain a motion to adjourn.
So moved.
All in favor? Aye. Stand adjourned.